Donald Trump just threatened to sue Trevor Noah. Not for a news report, not for an investigation, for a joke, a 30-second bid at the Grammys about Jeffrey Epstein's island. And here's what nobody's telling you. This isn't about protecting Trump's reputation. This is about weaponizing defamation law to silence speech. And from a prosecutor's perspective, Trump just walked into a legal minefield that could expose far more than he intended. Pay attention to what happens next. Sunday night, February 1st, 2026, the Grammy Awards. Trevor Noah is hosting for the fifth and final time. Billie Eilish wins Song of the Year for Wildflower. Noah makes a joke. That is a Grammy that every artist wants almost as much as Trump wants Greenland, which makes sense because Epstein's island is gone. He needs a new one to hang out with Bill Clinton. The audience laughs. Noah adds, "I told you it's my last year. What are you going to do about it?" By 10:01 a.m., Trump posts on Truth Social, not a quick dismissal, a 300-word threat. Let me read you the key parts. Noah said incorrectly about me that Donald Trump and Bill Clinton spent time on Epstein Island. Wrong. I can't speak for Bill, but I have never been to Epstein Island, nor anywhere close, and until tonight's false and defamatory statement have never been accused of being there, not even by the fake news media. Then comes the threat. Noah, a total loser, better get his facts straight and get them straight fast. It looks like I'll be sending my lawyers to sue this poor, pathetic, talentless dope of an MC and suing him for plenty. Ask little George Slopadopoulos and others how that all worked out. Also, ask CBS. Get ready, Noah. I'm going to have some fun with you. Now, Trump's referencing his recent wins. ABC News paid him $15 million after George Stephanopoulos said Trump was liable for rape when the legal finding was actually sexual abuse. CBS paid $16 million over a 60 Minutes interview edit. So Trump's feeling invincible. But here's where the case gets dangerous for him. Think about this for a second. What Noah said wasn't a news report making a factual assertion. It was a joke at an awards show by a comedian in front of millions of witnesses who understood it as satire. And satire about public figures has different legal protections than news reporting. But there's something else. Something Trump's lawyers should have caught before he hit send. On January 30th, just 3 days before the Grammys, Trump's own Justice Department released over 3 million pages of Epstein files. The Deputy Attorney General, Todd Blanche, stood at a podium and told America, "These files represent full compliance with the Epstein Files Transparency Act." And what's in those files? Trump's name appears more than 3,000 times. Let that sink in. The files include emails where Epstein and his associates shared news articles about Trump. They include photographs of Trump at Epstein's properties. They include a 2220 email from the Southern District of New York stating, "Donald Trump traveled on Epstein's private jet many more times than previously has been reported or that we were aware." They include testimony from one of Epstein's victims who said Ghislaine Maxwell made it clear she was available for Trump and his friends. The file noted nothing happened, but Maxwell's statements suggested the arrangement. They include testimony from Trump's own Mar-a-Lago butler saying Trump and Epstein socialize frequently, though Trump would eat in the kitchen rather than at the main table. Now, Trump has repeatedly denied wrongdoing. He's never been charged with any crime related to Epstein. Neither has Bill Clinton. Both men deny any knowledge of Epstein's criminal activities. But here's the prosecutorial question. If you're about to sue someone for defamation because they made a joke connecting you to Epstein's island, do you really want to open discovery on your relationship with Jeffrey Epstein? Because that's exactly what a lawsuit would do. Noah made a joke. Trump's response: "I'll be sending my lawyers. But before we get to why this lawsuit is legally doomed, We need to understand what Trump's actually trying to do here. And it's not about winning in court. Here's what they're not telling you about Trump's litigation strategy. Trump doesn't file lawsuits to win trials. He files them to create a chilling effect. From a prosecutor's perspective, look at the pattern. Trump has filed dozens of defamation suits over the years. He settles some, he loses most. But the point isn't the outcome. The point is the threat. When Trump sued ABC and CBS, those were news organizations with deep pockets and legal resources. They chose to settle rather than endure years of litigation, even though both had strong First Amendment defenses. ABC paid $15 million, CBS paid $16 million. That's $31 million for statements that were arguably true or substantially accurate, but technically imprecise. Now, Trump's applying the same playbook to a comedian, but here's what's different. Noah made a joke, not a factual assertion. And under First Amendment law established by the Supreme Court in Hustler magazine versus Fuel in 1988, satire and parody about public figures enjoy the broadest possible protection. Let me walk you through the legal standard. To win a defamation suit, Trump would need to prove 4 elements. First, that Noah made a false statement. Second, that the statement was about Trump. Third, that it was published to third parties. Fourth, that it caused damage to Trump's reputation. But Trump's not a private citizen. He's the President of the United States. That means he's a public official, which triggers a much higher standard under New York Times versus Sullivan from 1964. Trump must prove actual malice. That's a specific legal term. It means Noah either knew the statement was false or acted with reckless disregard for whether it was true or false. And here's the problem for Trump. You can't prove actual malice for a statement that's obviously a joke. In Hustler vs. Fuel, the Supreme Court addressed this exact issue. Hustler magazine published a parody suggesting Jerry Fuel, a prominent televangelist, had an incestuous encounter with his mother in an outhouse. Fuel sued for defamation and intentional infliction of emotional distress. The court ruled unanimously that parody, no matter how outrageous or offensive, cannot be defamation if no reasonable person would believe it's asserting actual facts. Chief Justice Rehnquist wrote, "The sort of robust political debate encouraged by the First Amendment is bound to produce speech that is critical of those who hold public office. Such criticism inevitably will not always be reasoned or moderate." The court continued, "Were we to hold otherwise, there can be little doubt that political cartoonists and satists would be subjected to damages awards, without any showing that their work falsely defamed its subject." Now, apply that to Noah's joke. Did any reasonable person watching the Grammys believe Noah was reporting a verified fact? Or were they watching a comedian host an award show making a satirical comment about Trump's documented friendship with Jeffrey Epstein? The audience laughed. That's evidence they understood it as humor, not reportage. But there's another problem for Trump, and this one's strategic. If Trump actually files this lawsuit, he opens the door to discovery. Let me explain what that means in practical terms. Discovery is the pre-trial process where both sides get to demand documents, take depositions, and gather evidence. It's the most powerful tool in litigation because you can compel the other side to produce materials they'd never voluntarily release. If Trump sues Noah for defamation over the Epstein joke, Noah's lawyers can subpoena every communication Trump ever had with Jeffrey Epstein, every email, every text, every phone record, every flight log. They can depose Trump under oath about his relationship with Epstein, how they met, how often they socialized, whether Trump ever visited any of Epstein's properties, what Trump knew about Epstein's behavior with young women. They can subpoena Mar-a-Lago employees. They can depose everyone who witnessed Trump and Epstein together. They can examine every document the DOJ just released and ask Trump specific questions about each one. Why would a prosecutor risk this? They wouldn't. Not if the actual goal was to win the case. But Trump's not thinking like a prosecutor. He's thinking like a politician using litigation as a weapon. Let's look at the timeline. On January 30th, the DOJ releases 3 million pages of Epstein files. The administration claims full compliance with the Epstein Files Transparency Act, but congressional Democrats immediately push back. Representative Ro K. Connor, who co-sponsored the law, says the DOJ said it identified over 6 million potentially responsive pages, but is releasing only about 3.5 million. This raises questions as to why the rest are being withheld. Representative Robert Garcia, ranking member of the House Oversight Committee, goes further. Donald Trump and his Department of Justice have now made it clear that they intend to withhold roughly 50% of the Epstein files while claiming to have fully complied with the law. So Trump's under political pressure about the Epstein files. His administration is accused of covering up information. Democrats are demanding to see the other 3 million pages. Then 3 days later, Trevor Noah makes a joke on national television connecting Trump to Epstein's island. And Trump responds with a lawsuit threat. Why? From a prosecutor's perspective, this looks like narrative control. Trump's trying to reframe the conversation. Instead of defending against accusations of a cover-up, he's going on offense. He's positioning himself as the victim of false accusations, pointing to the joke as evidence of unfair attacks. But look at what Trump actually said in his Truth Social post. He claims he's never been to Epstein Island, nor anywhere close. And until tonight's false and defamatory statement have never been accused of being there, not even by the fake news media. Is that true? Well, technically, most media reports have focused on Trump's social connections to Epstein, his trips on Epstein's plane, and the allegations in the DOJ files. Very few have specifically claimed Trump visited Little St. James, the island in the US, Virgin Islands. But here's the problem. Noah didn't claim Trump visited the island either. Listen to the joke again. Epstein's island is gone. He needs a new one to hang out with Bill Clinton. Noah's making a joke about Trump wanting Greenland as a replacement island, not asserting Trump visited Epstein's island. It's a satirical comparison. The joke only works if you understand the layered references. So Trump's lawsuit threat is based on a misreading or a deliberate mischaracterization of what Noah actually said. And that's going to be a major problem if this gets to court. But there's more. The DOJ files released on January 30th include evidence that directly contradicts Trump's claim that he's never been connected to Epstein's properties. Photos show Trump at Epstein's Manhattan townhouse. Flight logs show Trump on Epstein's plane. Witness testimony places Trump at Epstein's Palm Beach residence. Now, being at someone's properties isn't a crime, and Trump has consistently said he socialized with Epstein in the early 2000s, but cut ties around 2004, well before Epstein's crimes became public. But if Trump sues Noah over a joke about Epstein's island, all of this becomes fair game in discovery. Noah's defense would be simple. Truth is an absolute defense to defamation. If Noah can show Trump had extensive contact with Epstein, visited multiple Epstein properties, and was mentioned thousands of times in federal investigation files, then Noah's joke, which is satire, not factual assertion, is protected speech. And that's before we even get to the actual malice standard. This is bigger than one case. What Trump's doing here is part of a systematic effort to use defamation law to silence critics. And it's working. Not because he wins at trial, but because the threat itself changes behavior. Think about the calculus for a news organization or a comedian. If you report something accurate but imprecise about Trump, you risk a multi-million dollar settlement, even if you'd win at trial. The litigation costs alone can be devastating. ABC and CBS settled not because they were wrong, but because defending constitutional principles is expensive and time-consuming. 15 million, 6 million. Those are strategic business decisions, not admissions of fault. But here's what this does to democratic accountability. If journalists and commentators know that any critical statement about powerful figures could result in years of litigation and multi-million dollar settlements, they'll self-censor. They'll soften their coverage. They'll avoid hard-hitting investigations. That's not just bad for journalism. It's dangerous for democracy. The Supreme Court recognized this exact risk in Sullivan back in 1964. The court said that First Amendment protections must include breathing space for robust debate, even if that means some statements that turn out to be inaccurate are protected. Justice William Brennan wrote that we must protect even vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, because the alternative is a society where critics are afraid to speak. Trump's litigation strategy deliberately exploits the gap between what should happen legally and what happens practically. Yes, Noah would almost certainly win if Trump sued, but the process itself becomes the punishment. And there's another consequence nobody's talking about. If Trump does file this lawsuit and it goes to discovery, the opposition will have the right to examine every aspect of Trump's relationship with Epstein. That means deposing Trump for hours, maybe days. That means producing documents. That means answering questions under oath. Trump's lawyers know this. They have to know this. So why threaten the lawsuit? Because Trump's calculating that Noah won't want to spend years in litigation either, that CBS won't want another defamation battle, that the threat alone will make comedians think twice before making Epstein jokes. But here's where the calculation might fail. Noah's not a news organization trying to maintain relationships with sources and avoid controversy. He's a comedian at the end of his hosting run. He said it himself. I told you it's my last year. What are you going to do about it? And satire has the strongest First Amendment protections of any speech. Courts have repeatedly held that jokes about public figures, no matter how harsh or unfair, are protected unless they make specific, false factual claims that damage reputation. So if Trump actually files this suit, he's choosing the worst possible test case for his litigation strategy. He'd be suing a defendant with both ironclad legal defenses and nothing to lose. And in the process, he'd open himself up to discovery about his most sensitive political vulnerability. That's not strategy. That's hubris. From a prosecutor's perspective, Trump's Truth Social post looks like a message to other potential critics. Look what I did to ABC and CBS. I'll do it to you too. But the legal system doesn't work the way Trump wants it to. Courts can distinguish between news reports that make factual claims and jokes that everyone understands as satire. Judges can dismiss frivolous cases, and discovery rules apply equally to both sides. Here's what you need to understand. Trump's lawsuit threat against Trevor Noah isn't an isolated incident. It's part of a pattern of using litigation to suppress speech. And whether or not Trump actually files the suit, the threat itself has already achieved part of its purpose. But there's a cost to this strategy that Trump may not have calculated. Every threat, every lawsuit, every settlement creates public attention to the underlying facts. The ABC settlement brought renewed focus to the E. Jean Carroll verdict. The CBS settlement raised questions about interview editing practices across all networks. And this lawsuit threat, it's making millions of people Google Trump Epstein files to see what Noah was joking about. Sometimes the cover-up, or in this case the legal threat, draws more attention than the original issue. The rule of law depends on everyone, including the powerful, being accountable. That means journalists must be free to investigate without fear. Comedians must be free to satirize without censorship. And citizens must be able to criticize their leaders without legal retaliation. Trump's defamation strategy threatens all of that. Not because his suits have legal merit, but because the process itself chills speech. So, watch what happens next. Will Trump actually file? Will Noah and CBS fight back? Will this become another Hustler vs. Fuel moment where the courts reaffirm that satire is protected speech? The answer matters for everyone who believes in accountability, transparency, and the First Amendment. Stay informed. More truth and accountability.